So the DOJ, AG Bondi, 25 states, and now multiple two-way organizations have joined to support the fight against statewide concealed carry ban laws. That challenge is now heading to Supreme Court conference in just a couple weeks. So let's break down what is happening in this critical case. Now, before we jump into this Second Amendment topic, I want to address something that's very interesting and I want to bring to your guys' attention. I know a lot of you have followed the channel and you see a lot of the reports and stories and Second Amendment cases and laws that I discuss here on the channel. And maybe you've thought to yourself at one point, how do I avoid making mistakes that maybe cost me my 2A rights forever, cost me a ton of money and time away from my family? And you maybe don't know actually how to protect yourself and avoid becoming another statistic. Now, here's what I can tell you. There is a method, a legal method that I've been using for 6 years that helps keep me and hundreds of gun owners out of handcuffs. It's not legal insurance. It's not carry permits. It's something completely different. This is something that can help protect you even before one of these situations happens. But here's the thing, I've never shared it before. I've never, thought that maybe this is something that people would be interested in. But now I'm, gonna make it available to you guys, and it's only gonna be to a small group of gun owners who understand that staying free requires more than just good intentions. If you're someone who would like to protect yourself and your family instead of gambling with freedom and making huge mistakes, you can click the link down below to be the first to know when I reveal some of these, secrets and information and make it available for you guys. You can sign up for free right now to get, the priority access to this information that will be coming to you guys soon. As I mentioned in the intro, in this video, I have some updates for everyone in states like New York, California, Hawaii, and others who are currently facing attempts to ban concealed carry within those states. The Hawaii Wolford versus Lopez case is currently seeking emergency Supreme Court intervention. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that the state's catch-all public property ban is permissible under the Second Amendment. Now, recently, to the surprise of many, the Trump DOJ, AG Bondi, and the 2A Task Force decided to step up in support of this challenge. They filed an amicus brief to the Supreme Court arguing that it's finally time for them to review these carry ban cases, review these laws, which were passed in direct response to Bruen. They also pushed the court to correct the ongoing lower court defiance that is now developed after Bruen. They even snuck in a mention that it's finally time for the Supreme Court to review statewide rifle bans and magazine bans that have also been put in place. Now, this effort in this case has been joined by 25 pro-2A states who also are pushing for the Supreme Court to grant review to this issue. This challenge has gained a lot of momentum and now it's heading to Supreme Court conference in just a couple weeks. Now, if you're not aware of what this case involves, this revolves around a challenge out of the state of Hawaii, and it's a challenge to Hawaii's new laws that they passed on concealed carry in response to Bruen. This law, like other ones, tried to add more restrictions to concealed carry and create a default rule where individuals can conceal carry firearms at private property only if the owner of that private property that's potentially open to business, open to the public, they can carry there only if they get express permission from the owner, either through verbal consent or through a sign. This law made concealed carry even worse than the ones that existed prior to Bruen. And keep in mind, Hawaii already had a really bad system where they'd only issued a handful of permits over 18 years. And in one county, they had never issued a single concealed carry permit. But because of this and the change in the law, the plaintiffs decided to sue the state of Hawaii to strike down this law entirely. Now, on review, a district court issued what is known as a temporary restraining order, or a TRO, which was then later converted into a preliminary injunction. In that court decision, the court there blocked the private property rule as likely a violation of the Second Amendment, and they found that it was inconsistent with what the Supreme Court just said in Bruen. This case eventually made its way to the Ninth Circuit, along with some other challenges to the California concealed carry ban, which is very similar to what happened in Hawaii. And on review, the Ninth Circuit upheld the catch-all property ban and reversed the preliminary injunction that was issued by the district court. The Ninth Circuit relied on some older restrictions on hunting on private property to essentially support this statewide concealed carry ban. Now, after that, the plaintiffs asked for the Ninth Circuit to review that ruling en banc, but that was denied. The Ninth Circuit pretty much stayed true to their anti-2A stance. They avoided this like the plague, but you did have some judges like Judge Van Dyke write a dissent where once again they said that There, the Ninth Circuit en banc panel was treating the Second Amendment like a second-class right. But because of all of that, that has now led the plaintiffs to seek emergency Supreme Court intervention in this case. Now, this case has a hard road to get Supreme Court review since it's still at a preliminary injunction stage, and the Supreme Court has denied review to most of these cases at this stage. However, the United States support in this challenge now gives this case a better chance. So in the recent amicus brief filed by the Trump DOJ, they stated that the near complete ban is flatly inconsistent with Bruen and the long history underlying it. Bruen recognized that an ordinary, law-abiding citizen has a general right to publicly carry arms for self-defense. One of the interesting things also within this brief of the Trump DOJ and the administration there was that they pushed the Supreme Court to take the case at this preliminary injunction stage, despite the fact that the Supreme Court's track record shows that they do not grant review to these cases. Now, they point out that Hawaii in the Ninth Circuit also argued that there was nothing else for the lower court to develop at trial and no further evidence that was needed to be developed at the lower court level. Now, that's critical for what is now happening because Hawaii, in the response to the Supreme Court petition, say that the Supreme Court should kick this case down below because there needs to be more evidence, a final judgment, more legal analysis. But really, that's a trap that Hawaii just got themselves caught in because at the Ninth Circuit level, they argued that none of that was necessary. Hawaii also responded to the amicus brief of the Trump DOJ by saying that they're an uninvited guest and that the Supreme Court should ignore this amicus brief, but still the Supreme Court will have to consider it in some ways because, the United States Supreme Court was allowed to file that amicus brief to the Supreme Court. They also doubled down on saying that this case is too early for Supreme Court review and that the trial court should be given an opportunity to develop the record and rule on the merits of this case. However, like I mentioned, Hawaii just pretty much contradicted what they already argued in the Ninth Circuit. This was pointed out by one of the recent briefs filed by Mr. Wolford in response to this. In that brief, he stated that Hawaii argues that this court should deny this petition because the record is undeveloped. That argument is irreconcilable with the concession in the lower court that no such further development was necessary. At oral argument in the Ninth Circuit, Judge Schrodinger asked counsel for Hawaii, "Can I ask you a question on the preliminary injunction point? What else is there left to decide? And what else is there left to be litigated in this case?" And counsel for Hawaii responded to the Ninth Circuit that we think that there isn't anything. We think at the end of the day, these are not Second Amendment violations. So counsel's concession, they state on this issue, is a judicial admission which is binding and conclusive. That concession that there was nothing left to litigate was well taken by the Ninth Circuit and used by the Ninth Circuit to reach their determination. Now, in this response by Mr. Wolford, he points out that Hawaii is trying to argue, that their own state history also supports this catch-all carry ban and should trump the nation's history on concealed carry. He argues that Hawaii seriously errs in contending that because it has limited the carry of weapons in public spaces since at least 1852, its default rule is constitutional. Effectively, Hawaii, he states, is claiming that its tradition trumps the founding. That assertion, he states, is self-evidently frivolous. So here the plaintiff is pointing out a few things. He points out that Hawaii has already conceded legally in the Ninth Circuit and for the purposes of this petition that there is nothing further to be developed at the lower court level. Therefore, they cannot now argue at the Supreme Court level that they should punt this case for further review and further development in a final merits determination. They also point out that the state of Hawaii wants to rely exclusively on state-specific history and tradition, but that is not the analysis under Bruen. The state history and tradition does not trump the entire national history and tradition and what our founders stated when they codified the Second Amendment. He also points out that the Ninth Circuit relied on the concession made by Hawaii to reach their decision, and that means that they cannot now backtrack those statements to avoid Supreme Court review. So with the help of the Trump administration and the 25 states and all the organizations, the state of Hawaii might have actually got themselves caught in a significant trap that is now leaning towards or pushing the Supreme Court to grant review to this case. A lot of their brief by the state of Hawaii focuses on kicking the case for further development when they already conceded in the Ninth Circuit that none of that was needed. So this case is gaining a lot of momentum, and now it has been set for Supreme Court conference on September 29th, which means the Supreme Court really soon, in just a couple weeks, will now consider this issue of concealed carry bans once again. They will have to determine if they're going to grant emergency review to this case. Again, I will state their track record has been to avoid this at an interlocutory posture. They've avoided other cases in the past, but with this concession made by the state of Hawaii at the Ninth Circuit level, and with the US DOJ and the Trump administration pushing them for review, there is a higher likelihood that maybe they would grant review to this case. So now we're going to wait to see what develops and what happens after that conference. Usually after the conference, the following Monday in the order list, we get an indication from the Supreme Court what they plan to do. We're going to be waiting to see how this develops, and as we get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armscholar.com. Over there, we have a lot for you guys, channel merch, deals, coupons, all of that. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.